At 10 this morning, the Supreme Court of the United States dropped a decision that will reverberate across the country for decades, a ruling that legal experts are already calling the most significant on presidential immunity in American history. The case, Trump versus United States, asked a deceptively simple question with profound implications. Does a former president have absolute immunity from criminal prosecution for actions taken while in office? Chief Justice John Roberts, writing a 43-page opinion, delivered an answer that could not be clearer. No. The former president does not have absolute immunity from criminal prosecution. That immunity, the court explained, does not exist under the Constitution, and the indictment may proceed. The vote was 9-0. Every justice, including the 3 appointed by Trump himself, rejected the immunity claim. Unanimity at this level, especially when conservatives join liberal justices in such a definitive ruling, is almost unheard of. This was not a close call. This was the highest court in the land, speaking in one clear, unequivocal voice, and that voice said, no one, not even a former president, is above the law. 17 minutes after the opinion was posted, at 10:17 a.m., Donald Trump responded on social media. He called the decision wrong, claimed every president has immunity, and framed the ruling as political corruption, insisting he would not accept it. His statements were defiant, and they set the stage for a confrontation that will play out over the coming weeks. But the significance of what just occurred cannot be overstated. This is not just a legal loss for Trump. This is the Supreme Court, in full unanimity, rejecting the core legal defense he had used to attempt to avoid trial. 9 justices, including conservatives appointed by him, told Donald Trump that he is not above the law. That is a historic statement. That is a precedent that will stand far beyond any one case. And now, the road is clear for federal prosecutors to move forward with the trial, a trial that could begin within weeks. To understand the gravity of this ruling, it's essential to look back at how this case reached the Supreme Court. The timeline is telling. On August 1st, 2023, Trump was indicted on federal charges related to efforts to overturn the 2020 election. The indictment alleged conspiracy to defraud the United States, obstruction of an official proceeding, and conspiracy against rights. Almost immediately, Trump's legal team filed a motion to dismiss, asserting that a former president cannot be prosecuted for actions taken while in office. Their argument was constitutional and political. Prosecuting a former president, they claimed, would chill the exercise of executive power, subjecting all future presidents to politically motivated prosecutions the moment they left office. The stakes were not just personal for Trump. They were structural, touching the separation of powers and the functioning of the presidency itself. The district court rejected the immunity claim on December 1st, 2023. The judge ruled that the Constitution grants no such protection to former presidents, and, importantly, that Trump's alleged conduct attempting to overturn an election was not an official act protected by immunity. The ruling was then appealed to the D.C. Circuit Court of Appeals. On February 6th, 2024, a 3-judge panel unanimously affirmed the lower court's decision. They found Trump's claims without merit and confirmed that former presidents are subject to criminal law, just like any other citizen. Unsurprisingly, Trump appealed to the Supreme Court. The court agreed to hear the case on an expedited basis, and oral arguments were held on April 25th. Less than a month later, on May 20th, the Supreme Court issued its landmark decision. Hit that like button if you understand what just happened here. The Supreme Court, 9-0, told Donald Trump he does not have immunity from prosecution. Every legal avenue he had to avoid trial based on immunity is now closed. The decision is monumental, not just because it affects Trump, but because it sets an unambiguous precedent. Leaving the presidency does not shield anyone from the criminal justice system. This is the rule of law, plain and simple, reaffirmed at the highest possible level. Legal experts immediately began weighing in. Former acting Solicitor General Neil Katyal said on cable news that this was a complete rejection of Trump's immunity claim. He emphasized that a 9-0 decision is unambiguous. There was no division, no dissent, no ambiguity. The court is speaking with one voice, and that voice says Trump can be prosecuted like any other citizen. Harvard law professor Lawrence Tribe echoed this, noting that the Supreme Court has affirmed a foundational principle of American democracy. No one is above the law. The decision, Tribe noted, removes the last major legal obstacle to Trump's trial. This is the culmination of months of litigation, and it leaves prosecutors free to move forward with a case that has been meticulously built over years. At 11:15 a.m., Special Counsel Jack Smith, responsible for prosecuting the case, issued a statement celebrating the court's ruling. He emphasized that former presidents are not immune from criminal prosecution and signaled readiness to move to trial expeditiously, requesting a trial date within 60 days. That timeline, if accepted, could place the trial in mid-July, potentially overlapping with the 2024 election campaign. For Trump, this is not just a legal battle. It is a political and narrative battle as well, because the optics of a trial during an election year are profound. Trump's attorney, John Lauro, acknowledged the ruling while pivoting to a trial strategy. He stated that they would now focus on the merits of the charges and asserted Trump's innocence. This statement effectively conceded the immunity argument, but framed the fight ahead as political and substantive rather than procedural. Meanwhile, the White House issued a measured statement affirming the rule of law while refraining from commenting on the specifics of Trump's case. Republican lawmakers were divided, with some praising the decision as correct and necessary, while others criticized it, warning it could haunt future presidents and create a dangerous precedent. Senator Mitt Romney, for example, praised the decision, while Senator Lindsey Graham voiced concern about its long-term implications. The Supreme Court opinion itself is a masterclass in constitutional reasoning. Chief Justice Roberts begins by framing the question: does a former president have immunity from criminal prosecution for conduct that occurred during their presidency? The opinion reviews historical precedents, including Nixon versus Fitzgerald in 1982, which granted sitting presidents immunity from civil liability for official acts. But the court emphasized the distinction: civil suits versus criminal prosecutions, sitting presidents versus former presidents. The logic is clear. The distraction from official duties that justified immunity for sitting presidents does not apply once the president leaves office. The Constitution provides no explicit protection for former presidents, and historical practice offers no support for such immunity. Trump's concern that prosecuting former presidents would chill executive action was addressed and ultimately dismissed. The court acknowledged the risk of politically motivated prosecutions, but explained that these risks must be managed through prosecutorial discretion, grand jury oversight, and the requirement of proof beyond a reasonable doubt. Blanket immunity, the court said, is not the solution. The principle is stark and unambiguous. No person, regardless of prior office, is beyond the reach of the criminal justice system. This is the legal foundation upon which the next chapter of Trump's trial will be built. With the immunity claim resolved, the case now returns to the district court for scheduling. Judge Tanya Chutkan, who presides over the trial, has set a status conference for May 27th to determine a trial date. Prosecutors are signaling urgency, requesting a date within 60 days, which would position the trial for mid-July. Trump's legal team is expected to request delays, potentially pushing the trial into 2025. The judge will then decide the timeline. Jury selection will follow, the trial will commence, and ultimately, a verdict will be reached. Every step from here is now procedural, with the immunity argument fully resolved, leaving only the question of what the jury will decide. Trump himself has already signaled how he intends to frame the narrative. Social media posts, rallies, and video addresses have painted the trial as biased and politically motivated, claiming the judiciary and prosecutors are corrupt and that the jury pool is skewed. This messaging serves to preemptively delegitimize any potential conviction, positioning him as a victim of the system. Observers will now watch several key indicators over the coming weeks: how quickly the prosecution pushes for trial, how aggressively the defense seeks delays, whether additional appeals are filed, if plea negotiations occur, and how Trump escalates his rhetoric. Each indicator will provide insight into how swiftly this case moves toward resolution. There are three broad scenarios for how this could unfold. In the first, the trial happens quickly, potentially concluding before the election, which would have significant political ramifications. In the second, the trial is delayed until after the election, giving Trump potential leverage depending on the election outcome. In the third, a plea deal could be negotiated, providing some resolution while avoiding the uncertainty of a full trial. Each scenario carries its own legal and political implications, and all three are being actively monitored by both legal analysts and the public. The unanimity of the Supreme Court's decision cannot be overstated. This was not a narrow, ideologically split ruling. It was 9-0, a message that transcends partisanship. The three justices appointed by Trump, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all voted against him. This fact alone removes any credible claim that the ruling was politically motivated, making it extraordinarily difficult for Trump to argue that the court's decision lacks legitimacy. Constitutional law scholars, including Yale's Akhil Reed Amar, have called this decision as clear as it gets. Former presidents can be prosecuted, and the rule of law applies equally to all. In the hours following the ruling, Trump held a rally via video from Mar-a-Lago, attacking the Supreme Court, the prosecutors, and the judge, insisting the decision was rigged and that he would ultimately be vindicated. He framed the prosecution as a political attack aimed at preventing him from winning the 2024 election. This framing is consistent with a strategy we have seen before, casting legal accountability as partisan persecution. But despite the rhetoric, the legal reality remains unambiguous. The Supreme Court has unanimously removed the final obstacle to prosecution. The trial is now inevitable. The only questions are timing, strategy, and outcome. This ruling carries implications far beyond Trump himself. Every former president now knows that leaving office does not provide immunity from criminal prosecution. That principle, established by the Supreme Court in a 9-0 vote, is effectively irreversible without a constitutional amendment. It sets a precedent that will guide legal reasoning for generations, creating a landscape in which all former presidents are subject to the same criminal laws as ordinary citizens. The weight of this decision is monumental. It is not a narrow, temporary ruling. It is a clear and enduring affirmation that the law applies to all, regardless of rank, title, or office. As the May 27th status conference approaches, the legal world and the public alike are watching closely. The Supreme Court has spoken. Trump's immunity defense is over. Prosecutors are ready to move forward. The trial is coming, and with it, a confrontation between law, politics, and public perception that will unfold in real time. The decision was 9-0. The opinion is final. And the path to trial is now unmistakable, inevitable, and historic. With the Supreme Court having cleared the immunity hurdle, all eyes are now on the district court and the countdown to trial. The status conference set for May 27th is more than a procedural formality. It will signal the pace at which the case proceeds. Prosecutors, led by special counsel Jack Smith, are pressing for an expedited trial, requesting a date within 60 days. That puts the trial potentially in mid-July, a timing that intersects dangerously with the 2024 election cycle. From a legal perspective, this is urgency at its clearest. Prosecutors want the matter resolved while the public spotlight remains sharp, and before any potential election interference could alter the stakes. On the other side, Trump's legal team is likely to request delays, arguing that now that immunity has been rejected, they need more time to prepare a full defense. Every motion, every procedural request, every appeal will be scrutinized not just legally, but politically. The judge will have to weigh the need for timely resolution against the defense's claims for due process. Jury selection will be the first substantive milestone after the trial date is set. In Washington, D.C., the pool is under intense scrutiny because Trump has already framed the jury as biased in favor of Democrats. The selection process will involve careful vetting of potential jurors for both overt and subtle partisan leanings. Attorneys from both sides will interrogate the panel extensively, seeking jurors who can remain impartial in the face of a trial that has been public for nearly a year, that involves a former president, and that carries charges with decades of potential prison time. This is not a standard trial. It is a trial that tests the very ability of the judiciary to remain neutral when the defendant is a former president, a political figure with millions of supporters and global attention. The trial itself will be historic. Prosecutors will lay out the timeline of Trump's alleged actions, spreading false claims of election fraud, pressuring state officials to alter vote counts, pressuring the vice president to refuse certification of electoral votes, organizing and directing supporters to Washington, D.C. on January 6th, and failing to intervene as violence erupted. Documentary evidence, emails, texts, video, and witness testimony will be presented in meticulous detail. Every element of the alleged conspiracy will be scrutinized, and Trump's defense will be equally vigorous, focusing on challenging evidence, credibility of witnesses, and casting the prosecution as politically motivated. The courtroom will be under unprecedented media scrutiny. The global audience, as much as the jury, will watch every development, every objection, every statement. As the trial approaches, Trump's rhetoric continues to dominate public perception. He has already preemptively claimed the system is rigged, that the judge is biased, and that prosecutors are corrupt. This narrative is designed to undermine the legitimacy of the proceedings, and it serves a dual purpose, energizing his base while creating a public record of claims that any conviction is unfair. The balance between public opinion and judicial process will be delicate. Legal observers warn that while a jury must focus only on the evidence presented in court, the reality is that a trial of this magnitude cannot escape public scrutiny. There are three potential pathways that this trial could take. First, the expedited trial scenario. The judge sets a date in July, jury selection begins immediately, and the trial unfolds over 4 to 6 weeks. A verdict is reached before the election, resolving the legal question while Trump campaigns. This scenario carries maximum risk for Trump politically, as the optics of a conviction or acquittal during an election season could sway public perception dramatically. Second, the delay scenario. The defense succeeds in postponing the trial until after the election. If Trump wins, he could attempt to leverage his new term for legal advantage, though self-pardon remains legally untested and controversial. If he loses, the trial proceeds later, but with potentially reduced political stakes. Third, the plea deal scenario. Facing the likelihood of conviction and the collapse of immunity arguments, Trump might negotiate a deal, pleading to lesser charges to avoid prison time while accepting limited accountability. While Trump's statements suggest he will fight to the end, in practice, legal strategy often requires compromise when faced with overwhelming evidence and precedent. The implications of this Supreme Court ruling and the impending trial extend beyond Trump's personal fate. The decision establishes that former presidents, no matter their influence or political connections, are subject to criminal law. This sets a precedent that will guide how future administrations behave, how Congress considers oversight, and how prosecutors approach cases involving executive misconduct. The 9-0 vote gives the ruling exceptional weight. It is not a narrow partisan interpretation, but a clear affirmation of the principle that no one, regardless of office held, is above the law. Legal scholars, historians, and constitutional experts will cite this decision for decades, and it will fundamentally shape the accountability of the highest office in the United States. As the nation watches, the coming weeks will test the judicial system, the political process, and the public's trust in both. The status conference, the trial date, the jury selection, and ultimately the trial itself are now unavoidable milestones. The confrontation between law and politics, between accountability and rhetoric, will unfold in real time. Trump has exhausted the immunity defense. He has no remaining procedural avenues to avoid facing the charges in court. The trial is not a possibility. It is inevitable. The Supreme Court has cleared the final obstacle. The prosecution is ready. The legal machinery is in motion. The decision was 9-0. The opinion is final. The trial is coming, and history will watch closely as the process unfolds. Turn on notifications. Follow this channel. On May 27th, when the status conference begins and the trial date is set, you will see the live analysis, the breakdown of motions, the strategy from both sides, and the unfolding political narrative. This is not just a trial. It is the affirmation of a principle that no one is above the law, and the implications of this moment will echo through every future presidency. The decision was 9-0. The immunity argument is gone. The trial is inevitable. And the eyes of the nation, and indeed the world, will be watching every step of the way.